The Fifth Circuit unanimous decision, which found that suppressors are not arms and therefore do not trigger 2A protections, has now been withdrawn by the Fifth Circuit. This comes after the Trump DOJ changed their position and agreed that suppressors are protected arms and cannot be outright banned. And now it seems like something else huge may be happening in this challenge. So let's break down what is happening. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is to check out the free legal guide that we now have available. I made it free for you guys. All you have to do is put in your email, and then we email you over a PDF. And, we do some follow-up emails as well with free educational information. And you can also check out my website, armscholar.com. We have the legal guide over there. We have some channel merch if you want to get that, and some other things as well you can check out over on the website, armscholar.com. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was ruled on unanimously by the Fifth Circuit Court of Appeals, which has now also just been withdrawn by that same court. This case is U.S. versus Peterson, and it deals with the constitutionality of the NFA as it applies to suppressors. Mr. Peterson, in this case, challenged his conviction, essentially that he violated the NFA based on a theory that the NFA and its suppressor restrictions actually violate the Second Amendment and what the Supreme Court recently said in Bruin, Rahimi, and all these other 2A cases. On review, the Fifth Circuit 3-judge panel found unanimously that suppressors here are not arms and they do not trigger 2A protections. However, in response to this, the Trump DOJ through AG Bondi stated in their new brief to the Fifth Circuit en banc panel that suppressors are in fact arms and they cannot be outright banned. So this was a drastic shift in policy and arguments from the Trump administration. They changed position from the Biden administration, and now they are actually arguing that these types of items are protected arms. The caveat to that is they also argued that the Fifth Circuit en banc panel should not actually take this case, that they should not reverse what happened down below. Instead, they should send it back down to the 3-judge panel for new consideration and reevaluation based on what the Trump administration is now saying about suppressors being protected arms. This was a major shift on suppressor restrictions, and now in response to that, the Fifth Circuit panel that originally ruled in this case just decided to pull their prior opinion. Now, this could mean a couple things. First, the Fifth Circuit 3-judge panel could be deciding to rehear this case and re-rule on this challenge because the Trump administration has drastically changed their position and direction on this whole suppressor issue. But another option, based on what we've seen happen in other challenges like the FRT cases, the pistol brace challenges, what could be happening is the Trump DOJ could be moving to actually settle this suppressor lawsuit. That would be a very interesting development on this whole issue of suppressor restrictions, especially in light of the new Big Beautiful Bill and the $0 NFA tax change on suppressors and SBRs that recently passed in Congress. Now, for those not aware, in this case back in 2022, both federal and state law enforcement officers executed warrants at Mr. Peterson's home in Louisiana. That search warrant was based on issues with Mr. Peterson's operation of the gun store on his property, and the ATF alleged that there were issues with straw purchases, improper record keeping of 4473s, failure to complete some papers and send them and forward them to the ATF, and then they had some issues related to some products and some firearms that were sold at that location and later showed up at crime scenes. But out of this entire incident, it is the possession of a single solvent trap that led to this challenge. A solvent trap was found, I believe, in his home safe in his bedroom. It was not registered on the NFA, and so he was charged with violating the NFA because he had an unregistered suppressor. Now, in response to this charge, Mr. Peterson filed a motion to dismiss in the lower court based on the Second Amendment. However, on review, the court denied his motion to dismiss the indictment, and that later led Mr. Peterson to then appeal that decision and the denial of that motion up to the Fifth Circuit. On review, the Fifth Circuit sided with the then Biden ATF and the then Biden DOJ, finding that Mr. Peterson's motions were properly rejected based on the Second Amendment because they believe the Second Amendment does not protect these types of items. In their ruling, the Fifth Circuit stated that whether suppressors constitute arms is an issue of first impression in our circuit. Insofar as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looked at whether suppressors are a weapon of offense or an armor of defense, or are they used to cast at or strike at another, and the Fifth Circuit incorrectly found that they are not. They stated that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protections. That is wrong, they stated. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense, and unless a suppressor itself is thrown, it cannot do any casting or striking. The Fifth Circuit went on to find that a suppressor is not a necessary accoutrement of a firearm and that it is not required to make a firearm actually useful or functional. Based on that, they upheld the district court's ruling against Mr. Peterson. Mr. Peterson and his counsel originally decided to file for a rehearing en banc in the Fifth Circuit, and originally the Trump DOJ, when they got control of this case, they responded to the petition for a rehearing by still arguing that suppressors are not protected arms. But then they had a drastic shift in policy and arguments in this challenge. In that new brief, the Trump DOJ argued that in view of the United States, the Second Amendment protects firearms accessories and components such as suppressors. As a result, restrictions on the possession of suppressors burdens the right to bear arms, and a ban on the possession of suppressors or other similar accessories would be unconstitutional. The government's earlier argument to the contrary was incorrect, but the National Firearms Act's registration and taxation requirement is constitutional because it imposes a modest burden on a firearm accessory that is consistent with the nation's historical tradition, because suppressors are especially adaptable for criminal misuse. Accordingly, although rehearing en banc is unwarranted, the DOJ argued that the Fifth Circuit three-judge panel got the part of the analysis wrong and that they alone should actually rehear and redecide this case. The DOJ argued that a full en banc panel rehearing was not warranted to correct the decision down below. Instead, they're going to change their position and re-argue that, I guess, in front of the three-judge panel. We recently received an order from the Fifth Circuit with a notice that they have in fact decided to pull that prior suppressor decision based on what the Trump DOJ is now arguing in this challenge. The notice of the Fifth Circuit stated that pursuant to the court's directive, the opinion in this case has now been withdrawn. So there could be a couple things going on here, especially now because the Fifth Circuit en banc panel said that this issue is moot. And now you have the Fifth Circuit three-judge panel that originally ruled in this case. They have pulled that prior opinion, and now they're saying that there's going to be probably some drastic changes. But there are a couple things that now could be happening. Since the three-judge panel withdrew its opinion, that could simply mean that a rehearing and a new decision in this case is going to happen based on the Trump DOJ's change in position on the whole suppressor issue. However, since that opinion has been pulled and the en banc rehearing has been found moot, we have not seen the Fifth Circuit three-judge panel make any court orders rescheduling briefs or, asking for additional briefs or for a new hearing. Because of this, the second thing that could actually be happening now and could be signaled because of this is that the Trump DOJ may be moving to settle the dispute like they did in the whole FRT issue and the pistol brace challenges. We've seen an interesting trend of the Trump DOJ deciding to not litigate these 2A cases anymore, kind of find a middle road and, do settlements and maybe try to get small wins, but not, fully litigate these cases. So that could also be happening in this specific suppressor challenge. That, of course, would be very interesting coming off the heels of the Big Beautiful Bill and the $0 NFA tax change that happened with suppressors and SBRs. And if they decide to go down that route and, settle this case, it would be interesting to see, what form does that actually take? Is it going to be specific to just Mr. Peterson, or is it going to have some larger implications based on the NFA and suppressors and kind of change the landscape a little bit based on what the Trump DOJ decides to do in a settlement? Time will tell what the Trump DOJ and the Fifth Circuit decide to do with this specific challenge, but they decided to pull the prior decisions, change their position on these arguments, and now it seems like this is kind of delaying a bit, similar to what we saw with the whole pistol brace cases and the FRT cases. We saw a similar lull in change in position, and then soon we found out there was actually a settlement that was then reached by the parties. Regardless, even if the Trump DOJ does not settle this case, they're going to have to change their position for a new argument in the Fifth Circuit, and it's going to be interesting to see if that goes down that route. How does the Trump DOJ now handle this whole suppressor issue? So that's what's going on right now in the critical suppressor challenge that's in the Fifth Circuit. We're now waiting to see, how the parties decide to move forward in this challenge. As we get more information, as this develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Again, you can check out my website, armscholar.com. Over there, we have the free legal guide available for you guys. I will also link that down below in the details section and also in the pinned comment. And again, just check out the website, armscholar.com, where we have channel merch and other things available for you guys. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.